Good evening. It's again a Bombay High Court judgment under the GST Act, Goods and Service Tax Act. Citation is West India Continental Oils Fats Private Limited versus Union of India. Issue is tax is collected without authority of law. Then they have refunded the amount, tax amount, within the time limit prescribed under Section 54 of the CGST Act. Question is whether interest is payable or not. That is the question. When you see the facts, you will understand. Facts of the case: West India Continental Oils Fats Private Limited, I will hereafter call it as WIC. WIC paid approximately 2.5 crores on ocean freight charges for the goods imported at the ports. This was based on notification number 8 of 2017 integrated tax. This notification was challenged as unconstitutional. Bombay High Court held that the notification was unconstitutional and directed the GST department to refund the amount along with interest. So WIC, in pursuance to the judgment, filed an application for refund of rupees 2.5 crores, and they also demanded interest of 70 lakhs rupees. Because you collected the amount without authority of law, kindly pay interest also on that amount. Department refunded 2.5 crores of the IGST paid, but refused to pay the interest on the ground that refund was paid within the time limit of 60 days prescribed under Section 54/56 of the CGST Act. So there is a time limit for refunding the amount. Within that time limit, I have paid you the refunds. Hence, I will not pay any interest to you. That was the case of the department. This was again challenged by the WIC by way of a writ petition. Bombay High Court held the collection of IGST was by way of a notification, 8 of 2017. Read with some other notification is there. Let us not worry about that. That notification was held to be unconstitutional. The decision was based on the Supreme Court judgment in Mohit Minerals case, wherein Supreme Court held a separate levy of IGST by the revenue on the component of ocean freight under the reverse charge mechanism was in violation of the CGST Act and the overall scheme of the GST legislation. That was the judgment of Supreme Court. Based on that Supreme Court judgment, the Bombay High Court also held the levy of IGST is unconstitutional. Bombay High Court did not accept the contention of revenue that since tax was refunded within 60 days, no interest is payable. The court said the amount of IGST collected from WIC by revenue, they have refunded it, which is now refunded. It is not payable at all in law. Such a tax based on the said notifications were struck down by Supreme Court. The court reasoned, Bombay High Court reasoned, Section 54 of the CGST Act can only be applicable for claiming refund of any tax which is paid in accordance with law and under the framework of the GST Act. The said section would not apply in a situation where revenue has no authority to collect the IGST or any tax on reverse, in this case on reverse charge mechanism on the ocean freight. So interest is payable from the date of payment to the date of refund. This is important. Once the department collects any amount without the authority of law, then interest becomes payable from the date of payment to the date of refund. Further, Bombay High Court in its earlier order held, because first the notification was challenged. So in that order it held, wherever the refund is payable, the same shall be paid within 8 weeks with applicable interest in accordance with law. The words are wherever the refund is payable. So the court did not accept the contention of the revenue. The judgment of Gujarat High Court in Cosmol Energy Private Limited case would be applicable only to that petition. Because the revenue said, no, no, you cannot rely on that Gujarat High Court judgment because that judgment is applicable only to that petitioner. On that basis, you cannot demand interest from this petitioner by the WIC. Bombay High Court said it is trite law, TRITE, trite law, that a judgment is an authority for what it decides. Such decisions are in rem and the ratio cannot be restricted and are limited to the petitioner exclusively in that particular case. It's a well settled principle. Judgments of high courts, in the absence of any other judgment by the other court in respect of a central law, it binds all the authorities throughout India. So that was the reasoning. Then Bombay High Court said WIC is legally entitled to claim interest on such a refunded amount of tax paid, that is 2.5 crores, without the authority of law and contrary to Article 265 of Constitution. Bombay High Court relied on the judgment of famous Mafatla Industries case, which laid down the doctrine of unjust enrichment. It said that one cannot enrich oneself illegally. One is bound to return the amount wrongfully paid without legal authority. Not only the amount, but also the interest. Admittedly, WIC paid the amount of IGST, which the revenue utilized up to the date of grant of refund. Having utilized that amount, there is no justification, legal or otherwise, to deny interest. The Bombay High Court said to deprive interest to WIC would run contrary to the well recognized legal principle of restitution, which also finds statutory force under section 144 of the CPC, Civil Procedure Code. Hence, Bombay High Court ordered payment of interest from the date of payment to date of refund. Only thing is, what is the rate of interest? Because then whether they have applied the rate of interest prescribed under the Act, CGST Act, or it is the 18% interest or the bank interest rate, prevailing bank interest rate, that is not specified. Otherwise, maybe those who have not claimed, this judgment may be useful for them. Secondly, if any tax is collected without authority of law, then if you have paid the tax, then you can claim interest also, according to the principle of restitution. That is a good judgment. Thank you very much. Have a great evening. Bye.